There exists, particularly among the general public, a fundamental lack of understanding about what exactly it is that a public defender does, as well as a lack of understanding as to why our work is important. Of course, the simple answer to the question as to what we do is, when you hear the police in the movies reading a suspect's Miranda warnings, he says, you have the right to an attorney. If you cannot afford one, one will be appointed to represent you. Well, we are the lawyers appointed to represent those people. The question as to why our work is important then becomes, why do these people even need a lawyer? Please indulge me as I attempt to shed some light on that matter. There are primarily three things that motivate me in my life's work. First is the love of my fellow human beings I was taught in my Christian upbringing. The second is the intellectual exercise, that is the practice of law. And the third is a profound respect for the United States Constitution and a profound respect for all those who have made sacrifices of their lives, limbs, and psyches in defending the Constitution. We'll begin there. Our job as public defenders is to help ensure that you enjoy the protections of your right to free expression, guaranteed under the First Amendment, and your right to own a gun under the Second Amendment. But the bulk of our work concerns your Fourth Amendment right to be free from unreasonable searches and seizures, your Fifth Amendment right not to be compelled to give self-incriminating testimony, your Sixth Amendment right to have a competent lawyer, and your Eighth Amendment right not to be subject to cruel and unusual punishment. These notions apply no matter whether you're rich or poor, black or white, male or female, Baptist or Catholic, Jewish or Muslim. Under the Constitution, everybody here is entitled to the same rights. Whenever I think about the rights we enjoy and why those rights are so important, I think about the Omaha Beach landing scene in the movie Saving Private Ryan. Likely as not, those boys had little idea of exactly why they were there, other than to protect our way of life from a very real threat coming from the outside. Some were brave, but most, I suspect, were terribly afraid of the fate that lay before them. I worked part-time in high school in the parts department of the Chevrolet place in Camilla. The parts department manager was named Lewis Rivers. About 1971, when I was in the 11th grade, Mr. Rivers' son, John Wilson Rivers, was killed in Vietnam. He was a medic and had taken a bullet to the back of his head while tending to one of his fallen comrades. I didn't know John Wilson Rivers, but I knew Mr. Lewis. I attended the funeral, made even more solemn by the honor guard and the 21-gun salute, and heard Mr. Lewis's sobs as he mourned the death of his son. Many years later, sometime about 1992, after I'd finished law school, I had occasion to go to Washington, D.C. I went to the Vietnam Memorial and found John Wilson Rivers' name. As I rubbed my fingers over his name, etched into that black granite wall, I could not hold back tears as the memories from that funeral some 20 years earlier flooded over me. Saving Private Ryan was only a movie, of course, but the horrors of wars to defend our way of life were very real. They gave their lives, their limbs, and their sanity to defend the Constitution. We need to keep our memories of their profound sacrifices sacred. If you've ever been touched by the horror and tragedy of war, then you've likely asked yourself at least once, why? Why did these brave and not so brave soldiers have to suffer and die? The answer is they gave of themselves to protect the liberties afforded us by the Constitution. I want you to consider this for a moment. This is the Memorial Day display at the Hart County Courthouse. Note how straight the rows are. The crosses are arranged offset from each other in the two rows. They are held up by half-inch rebar that somebody drove into the ground. If you've ever driven a fence post into the ground, you know it takes special care to get it in there straight. Look at how straight and plumb each cross is. It is obvious that whoever is responsible for making each cross and installing this display did it with the utmost care and skill. That indicates to me that whoever the person or persons were, they performed this task with the utmost reverence for these fallen soldiers. And I want you also to consider that most of these crosses represent people who were killed in their 20s. Sons, brothers, fathers of children who were never able to know them, cousins, uncles. And also want you to keep in mind that these crosses represent the dead. They do not represent those who came back scarred in body or mind. And we, likewise, do not need to forget them either. I'm not ignoring the sacrifices that women have made in defense of our country, but the fact is most of these casualties of war were men. And what does this have to do with being a public defender, you may wonder? The answer is that not all threats to the Constitution come from outside our borders. Our Constitution makes us a nation of laws, and to preserve our liberties, we must be ever vigilant to ensure those laws are respected. I consider it the greatest honor and privilege to be able to live my life in a manner dedicated to the notion that the sacrifices that these soldiers made were not in vain. To begin this section, I first want you to know that over the years of doing this business, I can recall fondly the great number of police officers I've come to know for whom I have the most profound respect, both professionally and as human beings. 2 of them work for me as my investigators, and they will be the first to tell you that bad cops are a disgrace to the profession. But the fact of the matter is, not one of us is immune from the foibles of poor choices, foolish decisions, or irrational behavior. The Bible says in the 23rd verse of Romans chapter 3, we all have sinned and come short of the glory of God. For example, take a cross-section of the police officer community, and you'll find, just like a cross-section of any other community, the cream at the top, the dregs at the bottom, and all variations in between. And anybody can get pulled over at any time. Just ask former University of Georgia Athletic Director Damon Evans. And when you see those blue lights in your rearview mirror, you just don't know the character of the police officer who turned them on, whether he has a drug problem of his own, is looking for drugs, whether his wife just asked him for a divorce, or whether he's otherwise just having a bad day. Add into that mix that the financial incentive that law enforcement officers have to make cases. Any number of newspapers in the state of Georgia will have articles on a daily basis about some police officer being arrested or sent to jail. And it's not just police officers in our criminal justice system who find themselves subject to the various weaknesses that can befall a person. District attorneys can have their problems too. So can public defenders. Indeed, you can find weaknesses at every step of the criminal process. Even superior court judges sometimes exhibit serious moral shortcomings. And not just superior court judges, but judges on the federal bench as well. And these are just a few of those who get caught. The fact of the matter is that we are all subject to making bad choices to one degree or another. It's our job as criminal defense lawyers to assure as best we can that our clients' constitutional rights are protected at every step of the process. Police officers take an oath to uphold and protect the Constitution. They don't always abide by that oath. Thus, a very important aspect of our job as public defenders is to police the police. We do that by making sure there was nothing about the police behavior in a case that violated our client's constitutional rights. One of those rights we defend is your right to be free from unlawful searches and seizures. We help assure those rights, among other ways, by filing motions. This was a motion to suppress. Donald Glenn Carr was a lieutenant with the Madison County Sheriff's Department, a 17-year veteran in law enforcement. In this case, he felt he could simply walk up to a lady and tell her he was going to search her purse. When he searched her purse, he found a gun. Then he told her he was going to search her car. He found drugs. Jana Whaley, now Jana Jacobson, my chief assistant, filed a motion to suppress the evidence from this illegal search, saying Carr can't just search someone's purse without a good reason. Judge Hodges felt the search was legal, but when Jana appealed it to the Court of Appeals, the Court of Appeals said that Carr's search of the woman's purse and truck was in violation of her Fourth Amendment right to be free from such searches. In this case, that same officer, Donald Glenn Carr, a 17-year veteran in law enforcement, thought that an arrest warrant gave him the right to search every trailer in a trailer park for the person he wanted to arrest, even though there was no connection between the person he wanted to arrest and those other trailers. He found marijuana growing in one of the trailers. Jana filed a motion to suppress, saying that an arrest warrant for a named individual is not permission to look in other people's houses for that person. Again, Judge Hodges denied Jana's motion, and she took it up on appeal. The Court of Appeals said that Carr's search of the trailers was in violation of Jana's client's Fourth Amendment rights to be free from such searches. This is Donald Glenn Carr's booking photo. He had a drug problem. On November 2nd, 2010, he pled guilty to violation of his oath of office, an oath which includes that he protect and defend the United States Constitution, and he pled to theft by taking. He was stealing Lortabs out of the evidence locker. He received a sentence of 6 years, with the first year to be served in confinement. This was simply a tragically sad case. A number of the other cases Lieutenant Carr had made wound up being dismissed. Now, this is certainly not to condemn Lieutenant Carr. Rather, it is simply an illustration that we must all be vigilant for attacks on our Constitution. At one of these calendars in court, typically there is standing room only. All the seats are filled and people are lining the walls, and most of the people want to talk to us. We're trying to take applications from our semi-literate clients while simultaneously working out deals, trying to explain our client's case to them, trying to counsel them as to what would be the best for them to do, trying to determine conflicts, looking at the state's file to see if there's any way we can resolve the case there, and much, much more. A lot goes on in court. All too often the DA doesn't subpoena half the cases, and we don't get plea offers on half the cases, or we have not received from the DA's office all the evidence to which we're entitled in time to prepare for trial. Maybe it's because they just have too many cases to contend with, because law enforcement is just making so many cases, and the DA's office doesn't seem to be trying to weed out the cases. These are flowers and cookies that the Teasleys sent to Patty Provost, one of my assistants, after she helped them in their case. Here's that story. About 3 years ago, Mr. and Mrs. Teasley were charged with first-degree cruelty to children for allegedly breaking the leg of their 3-month-old child. The facts took the baby away from the parents. The evidence was very weak, and Patty had made numerous attempts to get the case to trial. She filed a motion for acquittal based on the denial of her client's constitutional right to a speedy trial. Our office had determined there was not a conflict of interest, so we represented both co-defendants in the case. Judge Hodges denied Patty's motion. Patty appealed. At the hearing on her motion, Patty only put the mother up, thinking her testimony would suffice for the father as well. The Court of Appeals reversed Judge Hodges as to the mother, saying that the mother had indeed suffered extra harm for the delay in getting her case to trial. The Court of Appeals did not find that the father had suffered similar harm, so Patty went to trial on the father. Indeed, it was a very weak case. There was simply not enough evidence for the DA's office to even make out their case that the father had harmed his child. Another note with regard to this case: in addition to what it cost Hart County to bring in a courtroom full of jurors one day and 13 the next, the state paid for the travel of a former GBI agent to Hartwell from Virginia and put her up for the night. We do it because we are a nation of laws, and our Constitution affords the poor the same protections as it does the rich. We do it because that famous first-century Jewish prophet said, "Whatever we do for the poor is the same as if we're doing it for him." This is by the front door in the lobby to our office. It is well acknowledged that poor people get short shrift, Shakespeare said. Through tattered clothes, small vices do appear. Robes and furred gowns hide all. Plates sin with gold, and the strong lance of justice hurtless breaks. Armored in rags and a pygmy straw does pierce it. The landlord for our office is an insurance agent. He got a speeding ticket in Cobb County. He called an insurance agent friend of his who set him up with a lawyer. He got out of the ticket. As he was leaving the courtroom, he thought to himself, of all the people in the courtroom, he was the one who could most easily afford the piddly fine. For those people, most of them poor, who didn't have a lawyer and for whom a piddly fine would be a big dent in their funds, weren't as lucky. We are public defenders because we have the opportunity and the ability to have a profound and positive effect on someone's life. In the context of the stimulating intellectual challenge, the practice of law, engaged in, at least under the best circumstances, noble competition against a worthy opponent, and the dignified arena that is the courtroom, as a champion for those in our society least able to defend themselves. This was done for me by a woman who appreciated my help in her case. I have a number of mementos like this from my years in this work. I helped this family about 11 years ago get their children back in a seriously contested hearing on the termination of their parental rights. I think the kids were 4 and 2 at the time. They keep in touch with me a number of times every year and always send me a Christmas picture. Here the kids look maybe 7 and 5. Here they are this past Christmas, and this is their note. To Mr. Shiver, hope you enjoy this picture of us. We think about you all the time, and me and the family praise you to others. Take care. We love you too. The boys are 15 and 13 now. This client was locked up in the Oglethorpe County Jail for 18 months awaiting trial on a murder charge. He was not happy with me. During that time, he wrote letters to the governor, the DA, the judge, the GPDSC, and who knows who all else, complaining of what a sorry lawyer I am and how I'm doing a terrible job representing him. I made numerous visits to the jail to see him and tried to help him understand that since there are only 2 terms of court in the Northern Circuit, things sometimes take a long time to get resolved. But he remained unhappy and was an extraordinarily difficult client. What few people realize about being a public defender is we don't get to choose our clients. We don't get to fire our clients. It is common for our clients like this one to complain and talk bad about us. And all we can do is treat them with respect and compassion and represent the hell out of them. After we finally tried this case, and it took a week to try, he saw that I was actually well prepared, and I fought like hell for him. During the trial, my wonderful wife baked him some banana bread. He really wasn't used to people extending to him this kind of compassion, and he wasn't used to having a competent and passionate advocate defending him. Nevertheless, he was convicted and sentenced to life plus 20 years. He made this needlepoint in prison for my wife and me. This large bear of a man sat in his prison cell and expressed his appreciation for my wife and me with every stitch, after having written condemning letter after letter about me for about 18 months, and even after I helped him get life plus 20. I do this work and put up with difficult people because sometimes I am able to touch their hearts. I can put my arms around them and tell them their life matters. Judge Roper could not have possibly been more wrong. His corrosive cynicism was distinctly unhelpful. His reasoning is totally belied by the fact that many exceptional law students turn down lucrative paying jobs with big law firms to do public interest work, like being a public defender, for poor pay, carrying way too big of a caseload.